Good morning. Welcome, everyone. We're sorry about the delay that we had. We had a little technical problem, and we're glad to get started now. Also, I might tell you that I kind of pulled my back out a little bit this morning, so if I stand up or walk out, it isn't only because I probably don't like you or what you're saying. It's probably because my back hurts. So just wanted to clear that to start with. I may stand for part of this. Anyway, we are called to order, and Mr. Stark, please read the docket.
Thank you, Mr. Chairman. Mr. Chairman, we're here for a proceeding regarding the oral arguments regarding procedural issues in docket numbers 2019-180E, 2019-182E, 2019-194E, 2019-195E, 2019-196E, 2019-197E, 2019-207E, 2019-208E, 2019-209E, 2019-210E, 2019-211E, 2019-212E, 2019-224E, 2019-225E, 2019-226E, and 2019-227E. Mr. Chairman, this proceeding has been scheduled for 10 a.m. in the offices of the Commission at 101 Executive Center Drive, Columbia, South Carolina 29210. And Mr. Chairman, the docket is in order.
Thank you. We'll take appearances now. Let's just start over here to the left, and you can speak from the table. But let me just go ahead and start this off right now. You can speak from the table to introduce yourself, but if you're going to say more than one sentence, I want everybody at the podium. So,
good morning, Mr. Chairman and members of the Commission. My name is Chad Burgess, and I'm appearing on behalf of Dominion Energy, South Carolina today.
Good morning.
Please get to a microphone. Sorry. I meant the table up, or if there was a mic at the table. You don't have one, I don't think.
May it please the Commission, good morning. My name is Heather Shirley Smith. I am counsel for Duke Energy Carolinas and Duke Energy Progress. And with me today is Rebecca Doolin, also counsel for those parties. Thank you.
Good morning, Mr. Chairman, members of the Commission. I'm Peg Fox with Burr Foreman McNair, and I am here today to represent Lockhart Power Company.
Mr. Chairman, members of the Commission, I'm going to have a change in my introduction for the first time in 20-plus years. I'll see if I can get it done without messing it up. But, Mr. Chairman and members of the Commission, I'm Richard Witt from the Witt Law Firm. Thank you. I'm here for SBA.
You handled that very well.
Mr. Chairman, members of the Commission, Bland Hallman with the Southern Environmental Law Center, here on behalf of the Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever.
Good morning, Mr. Chairman, members of the Commission, Jamie Golden, Nelson Mullins, Riley, and Scarborough, here on behalf of Johnson Development Associates.
Morning, Mr. Chairman. Jeff Nelson and Andrew Bateman for the Office of Regulatory Staff.
Okay. Anybody else? Okay. All right. I think we've got some preliminary things, some statements, preliminary statements to make. I'll call ORS first, then we'll move to other parties.
Morning, Mr. Chairman. Andrew Bateman on behalf of ORS. We do have a few comments that we believe may be applicable kind of in a generic sense to a number of these dockets. So if the Commission please indulge me, I'll go through those briefly. Initially, ORS would request that in any docket in which testimony is to be filed, the Commission would require that the utilities first file an application. This serves a couple of different purposes. One, once the application is filed, it enables ORS and other interveners to begin conducting discovery and an analysis on any data contained in the application. And two, it typically lengthens the temporal process from the beginning to the end, which enables more communication between all parties and enhances the opportunity to resolve any issues that may arise in those dockets. Two, ORS is familiar with the letter filed by Vote Solar Counsel Thad Coley on July 3rd regarding net energy metering, in which Mr. Coley discusses the merits of having stakeholder processes. ORS certainly understands and appreciates the merits that go along with having stakeholder processes. However, if the Commission were to go down that path and require that stakeholder processes occur, ORS would request that the Commission would request that the utilities hire an independent third party to conduct these stakeholder processes. From my understanding, this has been done in other states with regards to net energy metering, and it's been done successfully. Third, ORS would request that where rates are impacted by any applications that the utilities file in these dockets, that the Commission require the utilities to file notice of those impacts. This would serve a couple of purposes. It would heighten any transparency in those dockets then occurring. It would also encourage public participation. And fourth and finally, as I'm sure that the Commission is aware, ORS, when it hires these outside consultants, hires them pursuant to South Carolina Code 58-4-100. Now, under that statute, where the utility, or where ORS hires these consultants and the utility agrees to pay for these consultants, the utility is entitled to rate recovery of the cost for those consultants. That ultimately gets passed on to ratepayers. As a result, where ORS hires consultants in these dockets, ORS would request that the Commission allow the presentation of these witnesses via video conference. This has been demonstrated to work successfully over the past couple of weeks. The Commission has interviewed a number of consultants via video conference, and ORS believes that if the Commission were to allow this, those cost savings will be passed on to ratepayers. That concludes the sort of few generic comments that ORS has. At this point in time, I'm happy to take a seat, and we can go with whatever procedure the chairman sees fit.
Thank you. Any other preliminary matters that we need to hear? Mr. Smith.
Mr. Chairman, and members of the Commission, one preliminary matter that we see is while the Commission originally asked for comments from interested stakeholders, we're now moving into oral argument land, and if the Commission issues an order with legal consequence coming out of this oral argument, then rights accrue from that, including appeals, rehearing, et cetera. Don't know if we'll wind up there, but in particular, Duke Energy is concerned about the Commission hearing arguments from parties who have not intervened in our docket. So we raise that. We object to any party who has not intervened in our dockets being heard by the Commission making substantive arguments about what should happen in our dockets. Commission Rules 103-825 and 103-805 are very clear in terms of giving parties the right to participate. And now that we've moved into sort of a different phase, we raise that concern and that objection for the Commission's consideration. Of note, Johnson Development has not intervened in our integrated resource plan dockets.
Thank you. Mr. Golden, we'll hear from you.
Mr. Chairman, members of the Commission, Johnson Development has filed and been granted intervention status in 3 of the dockets applicable to each of the Duke companies. Council is correct that we have not been granted intervener status in the IRP proceeding as of Duke Carolina, Duke Energy Progress. I don't recall any date has been set as a cutoff for intervention in those dockets. I'm not exactly sure why the utility is so concerned about our testimony being hurtful or impactful, but you know, we find ourselves here. I would say that the commission has a charge to encourage full participation, and I would request that since no deadline has been set, since that we are interveners in the other dockets that are listed on this notice, that our comments not be precluded from being made if we have any. And again, I would say that the goal of the commission is the further participation by the public and by potential interveners. And I find it somewhat, I'm miffed that the utility would come and say this.
Thank you. We don't argue that Johnson Development continues to have a right to intervene. Our issue is that the commission is hearing legal arguments from non-parties today. So if Johnson Development intervenes next week, we'll look at that intervention, likely not have any problem with it. But we've gone from interested parties making comments to now oral arguments, and we think the commission requires intervention. We don't object to Johnson Development making any comments about any docket in which they've intervened. We are trying to be flexible. For example, SCLC has not been granted intervener status, but they did go through the process of intervening, for example, in those integrated resource plan dockets. And so we have no objection to their participation. But this is a technicality, but we think it's an important one, and would like our objection noted for the record as it pertains to the 2 integrated resource plan dockets of Duke Energy.
Thank you. So why have you intervened in some and not all of them?
Mr. Chairman, we plan to intervene. The deadline has not been established yet. Certainly, I think all of y'all will agree that as to Act 62, the PURPA implementation is probably at the first and foremost of everyone's mind. But there is an intent on our part, and I will state that on the record, to intervene, to timely file and intervene.
May I ask a question, Mr. Chairman?
Absolutely.
Ms. Smith, what would prevent Mr. Golden from moving to intervene now?
The Commission Rules 103-805 gives parties a right to participate, and Commission Rule 103-825 sets out the Commission's requirements for filing a petition for intervention and what actually goes into that petition, and which the Commission typically puts on an agenda for notice and a public vote.
Mr. Golden, do you have your petition ready to file?
Judge Irvin, I would, along that line of thinking, I don't have it physically with me, but it is in the office. What I would do, without objection, under the rules of the commission, I can orally ask for a motion to be granted, a petition, an oral petition to be granted to intervene in the IRP proceeding for each of the utilities here today.
Ms. Smith, would you object to that?
I would object to it only because it's not allowed by the rules, but I have no problem if Mr. Golden wants to proceed with his comments, and if we perceive any harm or anything that comes out of those comments being prejudicial or granting appellate rights where none would otherwise exist, we're happy to proceed, but we did want our objection noted for the record. And it may actually be a non-issue, but we're into a different area now, and the technical components are important to us. But we have no objection with proceeding, given those caveats and that objection on the record.
Well, if you feel like you're being prejudiced by allowing Mr. Golden to intervene, please call it to our attention.
Yes, sir.
Otherwise, Mr. Chairman, I think as a courtesy to move things along, Mr. Golden, can you file your petition immediately? Can you text your office and have them file it electronically?
I handle most of my filings, which is weird for a big law firm, you would think. I can have it filed by close of business today, or to prevent this from being an appellable issue, I won't talk about our IRP. How about that? Let's just take it off the table. I think that's the higher ground, and I'd prefer going that route.
Okay. We'll note the objection. Thank you for that.
Mr. Chairman?
Yes, sir.
Mr. Chairman? Hey, this is
Commissioner Williams. Welcome.
Thank you. Thank you. Good to be heard. I appreciate Attorney Golden's willingness not to discuss Johnson Development's IRP, but I also want to make sure that this proceeding allows for all interested parties to have their say. I don't want to put Mr. Golden on the spot, nor do I want to waste the time of the commission, but would a quick recess allow for you to file this petition so this will be a non-issue? Because if I understand Counsel Smith's argument, it seems she's really arguing a technicality, and I understand that she has to protect the record for her client, but it merely seems like a technicality that could be overcome with a simple filing.
I think, Commissioner Williams, that I think we'll get the full. If Mr. Golden has already agreed not to speak on the IRP today, and
Mr. Chairman, if I may, Commissioner Williams, I appreciate your thought there. I do think Duke would not be willing to waive the 24-hour notice requirement or the 5-day. I can't recall what it is in the rules. 10 days.
10 day.
As our very seasoned Commissioner Belser lets me know. So I think, given that, like I said, since I don't want to do anything that harms these proceedings, I appreciate the thought, Commissioner Williams, and certainly that's not lost.
And I'll just reiterate, if it makes things easier, if Johnson Development wants to, commits to intervening today, we can move on. We just thought it was important to point out this technicality. I don't know that we have any plans to object to their intervention, but we did want the process followed. So if our intention was not to hamstring these events, but to point out a technicality and have it be cured.
Ms. Smith, are you saying that if council says, yes, we will intervene, that y'all wouldn't object even if they comment on the IRP dockets?
I think we preserve our rights to object, but we don't have a problem with them proceeding today. And if they're not allowed intervention, I don't have any plans to do it right now, but if they, that we can always make a motion to strike or something, but that way they're heard.
Okay. Mr. Golden, I think you indicated y'all plan to intervene, is that correct?
Yes, Commissioner, that is correct.
Doesn't that, okay, your rights are on the record, or you've got your, if the chair sees fit to say you can file that later, you'll file your petition to intervene, and under the regs, parties have 10 days to object, and then it'll go on the agenda for acceptance or not.
Yes, Commissioner.
Is that, are we okay?
Good.
Yes, my main concern was preserving our objection.
Thank you. Thank you both.
Thank you.
So preserved, Mr. Burgess.
As long as that's going to be preserved for Dominion Energy, we have no objection to Mr. Golden making whatever argument he wants to make today with respect to the IRP.
Thank you. So noted. Okay. Okay. Now that we've got that behind us, let me adjust. And we will start with the move-ins. Mr. Witt, from the Witt Law Firm.
Mr. Chairman and members of the commission, I'm Richard Witt here for the South Carolina Solar Business Alliance. And the South Carolina Solar Business Alliance certainly appreciates the opportunity to be heard today. And for the benefit of everyone, since there was a late e-filing by Rebecca Doolin yesterday, I want to have an introduction to how that occurred. Rebecca filed a correspondence that was approved by DEC, DEP, DSC, SELC, and SBA. And in it, Ms. Doolin notified this commission that the parties are in general agreement on the following matters: the generator interconnection procedures, the voluntary renewable energy program, community solar program, and net energy metering. And the result of that consensus is that all the persons agreeing to that agreed there's no commission action necessary at this time on those items. So that that compresses what we have to talk about here today. However, that same correspondence from Ms. Doolin indicates that the three utilities are in disagreement with SELC and SBA on the need to establish a generic docket, and that docket would adopt a uniform set of filing and reporting procedures. So I will discuss that. And the paramount concern for SBA on the IRP is that there be transparency and front-end participation, because in our experience, when there's transparency and front-end participation, that leads to a better process and resulting consistency between the three utilities, which is obviously a concern. Mr. Chairman, members of the Commission, as to the IRP, in June and July, SBA filed comments on the IRP, and we commend those comments to you. They're much more lengthy than my summary this morning. And consistent with those filed comments, and as I mentioned, Act 62 has brought fundamental change to IRP, and as a result of that, there's been a significant expansion of the Commission's authority on IRPs. So as a result of that expansion of authority, the Commission should establish a generic docket for a uniform set of filing and reporting requirements. And this is not without precedent, the generic docket that SELC and SBA is requesting. In 1991, this Commission conducted a generic docket, and it was order number 1991-1002. And that provided our protocols and reporting procedures. And the fact that the Commission would do that in 1991 in a more kinder, gentler time than we're in now, it's obviously to us that it's much more important to have such a thing now with Act 62 and the dramatic changes that have occurred. So Act 62 also has a provision in it, which I'll read into the record, 583740E, and that authorizes this Commission to promulgate regulations, which once again we believe shows the seriousness of the changes to the IRP that can occur. Now, as of today, SBA is not recommending that this Commission promulgate new regulations, but we want to point that out, and it may be required in the future to work these things out. We do think that the appropriate and necessary thing would be a generic docket. With respect to the timing of consolidated docket, there's no timeline for implementation, but we believe that the Commission should establish a procedural schedule for early 2020, which would allow that process to be completed later on. And these steps would ensure that future procedural schedules are more workable. In the past year or two, we've all seen that there is an interplay between avoided cost and IRP, and this Commission has recognized that that's important. So we believe that a generic docket would certainly aid in that. The other issue besides IRP for SBA is an integration study, and that has not had a lot of activity before this Commission, and once again I'll read that statute into the record. 583760. That permits this Commission and ORS to initiate a study into renewable energy, the integration of renewable energy and energy techniques for the public interest. SBA also filed comments on an integration study earlier and on July the 5th, and we commend those comments to you for further detail. The integration study, we believe is critical, and I'll publish 4 reasons. These issues will soon be before this Commission: integration cost, interconnection, grid modernization investment, and IRPs. And we believe that the integration of the study of renewable integration is significant because the commitment that the General Assembly has made everybody aware of, including this Commission, that it's important in enacting Act 62 that we have an integration. So based on the importance and complexity of renewable energy, and the Act provides you flexibility, we recommend the Commission initiate an integration study, but after the avoided cost proceeding. And that concludes my summary, and we appreciate the opportunity to appear in front of you, Mr. Chairman, members of the Commission.
Thank you. Anyone else from movements?
Very briefly, I want to echo what Council Witt said. The integration study is something that has not been talked about a lot, but Section 8 of Act 62, very important. It does authorize the Commission and the ORS to commission an integration study to see how this impacts our system, how it impacts renewable energy development in the state. And I would propose, and y'all shot me down the last time, but we had the generic docket, and essentially this is one of those issues that's not going away anywhere soon, because if you look in 583760 sub B, the commissioner may require regular updates from utilities regarding the implementation of this. So it's something that we foresee the study happening initially and the commission flexibility to come back later on. And so I would say that it would probably be proper to at least get on the record that there's an intent by the commission or the ORS to have an integration study done. The good news is, I'm here to tell you that doesn't have to be done this year. It's not like we're asking you to do it before January 1st. 2020, 2021, that's fine, but just a willingness on the part to acknowledge that. And I think it's so important that the General Assembly gave y'all the authority to do this independent integration study, because they, as we know about independent consultants, gave the same authority for you to retain an independent consultant to handle this study. And they exempted you from their procurement code, which, again, shows this was a section that I think has been overlooked by all the parties. And I just want to raise that to your attention, because I think it impacts all of the dockets that we're here to discuss today. And I think it has an impact on the other Act 62 dockets.
Thank you. Mr. Holman.
Thank you, Mr. Commissioner, Mr. Chairman, members of the commission. I would like to speak about the IRP process. Just quickly, I've been involved in IRPs for years, and this commission has been involved in IRPs for years, decades. And the Energy Freedom Act really hits the reset button on IRPs. I mean, for the first time, y'all are going to be approving these things. We're going to have proceedings. They'll be appealable. And for the first time, you've got a statute that sets out a lot of requirements for IRPs. And you might think, well, now, if it's so many requirements in this new statute, who needs a generic proceeding? It's self-executing what this means. That's an understandable view, but I think it's the wrong view. It's not the best view. The details in here, this may come as a surprise to some people who are not lawyers, but the more details you have written into a law, and the more words you have, the more chance you have for disagreement. And there are words in these provisions like reasonable plans. The IRPs have to contain various reasonable scenarios. They have to have low and medium and high cases for efficiency. Those things mean those words mean different things to different parties. And just to illustrate, SE&G in its IRP, as we see it, this commission directed them to provide cost numbers for some of their scenarios. And instead, what SE&G was provide a ranking of those scenarios. Now, in their view, they might have been complying with what y'all told them. In our view, they didn't. Each one of those disagreements, each one of these areas in the statute, I think is going to be subject to reasonable disagreement. And so I think that your work would be minimized and the public would benefit most from having a generic proceeding at the outset to understand better what this means. And IRPs, this is not some kind of reporting requirement here. This is fundamental to how these utilities operate, plan, how the avoided cost rates are set. So this is not a minor thing. This is the starting point for a lot of the activity that goes on in this commission, and it's evident that the General Assembly has signaled a new day in many different departments, but in the IRP world in particular. And I just want to point out, one of the lurking issues here would be, for example, we have a state energy plan in South Carolina. South Carolina Statute 48-52-210. I've never litigated it in this forum, I don't think. It calls on the state of South Carolina to maximize environmental quality, conservation, and efficiency. It is the policy of South Carolina to do these things. It is a statute. You're going to be presiding over reviewing the plans of these utilities to set the energy future in South Carolina. How does that statute interact with those integrated resource plans? That is exactly the kind of issue that's going to cross-cut on all these utilities, and that it would be good to have this commission resolve at the outset before we get into the weeds on those proceedings. So a generic proceeding can surface some cross-cutting issues, resolve them, and do it in a way that saves time overall and is better for the public understanding of how this process works. Statute, as Mr. Witt mentions, discusses your authority, gives you authority to set regulations. Does not require that you do so. I think the fair reading of that is they understand they're giving you a big bunch of work, honestly, here, and they want to give you the tools to do it right. I think a generic proceeding, as you've done in the past, is a tool in your toolbox you can use, and we would encourage you and ask that you set it up with generic proceeding first, and then we can get to the specific IRPs in 2020. Thank you.
Thank you. Anyone else from the movements? I thought you were going with that more words meant you, for us non-lawyers, meant you lawyers get paid more. I got you. Okay, let's move to the utilities.
Good morning, Heather Shirley Smith again on behalf of Duke Energy Carolinas and Duke Energy Progress. Just a couple of responsive points. Should the Commission and ORS decide to initiate an integration study, we agree that that is not an immediately burning issue, so we agree with the movements on that part. We do believe that that is a utility-specific endeavor within Act 62, 53, 3760 subsection A. The Act is clear that studies shall be based on the balancing area of each utility, and so we think that that is an important component in looking at a study for each utility's balancing area. This is especially important to Duke Energy Carolinas and Duke Energy Progress since our balancing areas cross state lines, and there are some complexities with that. So we believe that those are utility-specific studies should the Commission and ORS decide to initiate them. We would like to speak to the issue of guidelines that have been proposed for the IRP. Most of our comments can also be found in our July 5th filing in our IRP dockets, but just to reiterate some of them fairly briefly, we agree that the new IRP statute is robust. South Carolina Code 583740 grew by approximately 1,000 words. We believe that the legislature gave plenty of direction as to what next steps the Commission should take, what the utilities should file, what those proceedings will look like, down to enumerating even discovery rights within the statute. We agree with the movements that there's no doubt that the very end of the IRP statute empowers this Commission to promulgate regulations. We don't dispute that. But we also note that promulgating regulations are terms governed by the Administrative Procedures Act. So we believe that words matter in the statute, and if the Commission wants to promulgate regulations, it is certainly free to do so. But we know that promulgating regulations is not the same thing as issuing guidance. Under South Carolina Code 12310, Section 4, if a policy statement from the Commission is not promulgated as a regulation, it does not have the force of law. And I'm quoting, "Policy or guidance issued by an agency other than in a regulation does not have the force of law." And the process for promulgating regulations in the Administrative Procedures Act can be found in South Carolina Code 123, 110, and 111. It appears to the companies that the parties are proposing guidelines instead of regulations. And guidelines here are in the abstract. So no one has proposed any specific language as to a guideline. Instead, there's a reliance on prior commission practice. But I'd also note in the commission's orders detailing the history of those guidelines, in Commission Order 98-627, the commission noted that the guidelines process that happened over a number of years was a collaborative process, and it was actually initiated by Duke. So it's a very different scenario. And so where those guidelines were filling in potentially gaps, we feel that the statute has filled in those gaps. So while the commission has issued guidelines before, they were without material objection, and it was a collaborative process versus what the movements are proposing. We believe that the legislature outlined exactly what should go into an IRP. No party has clearly articulated a precise need for what should go in those guidelines. And if there is any doubt whether the commission should be issuing guidelines or regulations, we would point to Home Health versus South Carolina Tax Commission, that's a case cited in our July 5th filing. And that case makes clear that if it's a close call between a policy or a regulation, it should be a regulation. We agree that judicial economy is important here. Time is precious. The legislature gave this commission and those participating in this proceedings a heavy burden to work through all of the proceedings that the Act, a heavy burden and an opportunity, to work through all of the proceedings that the Act calls for. And our question really when it comes to guidelines, if they're not binding, if they're not binding and guidelines aren't binding under the law, then why are we doing them? There are plenty of other dockets to be focused on. We believe the better process is for the utilities to follow the direction that the legislature gave in the IRP statutes, make their filings, and if they are deficient, the Act has teeth. If those filings are deficient, then the commission is empowered under Act 62 to reject the filing, to modify it, to require the utilities to refile, and after we get through that process, if there are gaps that need to be filled in by regulation, then that might be a better use of the commission's time to promulgate regulations at that time. There have been some questions about phrases from the Act. What is a reasonable scenario, for example? We don't think that's the kind of binding norm you can implement via a guideline. We think what is reasonable is a question of fact, and the companies should be allowed to present what they believe is reasonable, and the commission can make its decision upon whether it is upon the company's representation and full participation from the parties as to their view of whether what the companies proposed are reasonable. In sum, that we believe that path is a better path toward judicial economy, is compliant with the Act and the Administrative Procedures Act. Thank you.
Thank you. Mr. Burgess.
Good morning, Mr. Chairman, members of the commission. I'm Chad Burgess for Dominion Energy, South Carolina. And at the outset, I do want to thank our co-counsel in this docket for working with us over the course of Friday and over the weekend as far as putting that letter together. I think that showed a lot of good collaboration among the parties. It is unfortunate that we can't come to you with everything resolved and bundled up, but I want you to know that was certainly our sincere hope as we move forward through this process. And I'm not giving up. So we'll continue to work with the other parties and hopefully find some grounds of agreement. But with respect to the IRP, like I said, that is unfortunately one area in which we are not in agreement on. We believe that the statute is very prescriptive. It tells this commission exactly how to handle an IRP docket. It tells the utilities exactly what is to be included in their IRP, and the utility intends to file its IRP consistent with Act 62 and what's required of it in there. Now, I certainly have heard some discussion about front-end participation and transparency, and I think everybody will agree that that is a nice have. Unfortunately, what we're left here with is what the General Assembly allows us to have. And the General Assembly did not tell this commission to hold a generic proceeding. The General Assembly did not tell this commission to hold any other type of proceeding other than what's promulgated in the statute. And in fact, I would argue to this commission that by the General Assembly stating in here that if you want to do something in furtherance of the IRP, subsection E specifically tells this commission what to do, and that is to promulgate a regulation. And as Ms. Smith just articulated to you, there is a process and a procedure by which the commission is required to follow in order to enact a regulation. Dominion Energy intends to file its IRP on February 28th of 2020, and we will follow the law with respect to that IRP, and then we will conduct annual updates in accordance with the law. But as I said earlier, the statute is prescriptive in what's required in an IRP, and we intend to follow that. With respect to, I want to circle back to ORS. They had a few requests of this commission, one of which was one I heard for the very first time, and that was the request for utilities to submit an application along with their testimony. I have not had a chance to consult with my client about whether or not they would be agreeable to that. So I would ask that this commission hold that issue in abeyance, at least for the time being, to allow me the opportunity to ask Dominion whether or not it's agreeable to that. To the extent that that is not afforded to us, unfortunately, I would have to go ahead and err on the side of caution and place an objection on the record that we be required to file an application with our testimony. I'm not aware of any statute or any regulation that this commission has promulgated that requires utility to do that, so we would object on those grounds. With respect to the Volt Solar letter and the stakeholder process, to the extent that there is a third-party independent moderator who's hired, Dominion would not object to that as long as there is a mechanism by which we're allowed to recover the cost of incurring that expense. Thirdly, with respect to rates being impacted, I don't believe that the utility would have any problem with submitting a notice if there is a rate impact associated with any filing, so we would be fine with that. And then lastly, Mr. Bateman reiterated the letter that ORS had submitted with respect to the video conferencing, and I would just like to take this opportunity to remind the commission, Dominion did submit a letter in response to that, and we indicated that we had no objection with that request. So if the commission is inclined to grant that, again, we have no issue there. The integration study that's called for in the act, I think the statute's pretty clear on that point. You clearly, you, the commission, and ORS are authorized to undertake that endeavor. So if that's something that you decide is appropriate, then you certainly have that right to do so under the law. I agree with Ms. Smith. It does talk about studies, and our balancing areas do have different characteristics, and we would just ask that if there is a study that is undertaken, that each utility have a separate study for their specific balancing area. And lastly, Mr. Chairman, if I've already hit on this, I'm sorry, but I think it's important, worth repeating. I've heard a lot about the term generic proceeding, and I have looked where generic proceeding is in the law. I can't find it. I haven't heard any of opposing counsel cite to you the specific regulation or code section that authorizes a generic proceeding. I do recognize that the commission has done that in the past, but I have not seen where that is specifically given to y'all. I'm happy to let somebody inform me of that, but I do want you to know I've looked high and low for that, and I cannot find that. Because there's no basis in law for that, at least what I've been able to find through my research, I think you should reject the argument that's being advanced by the other parties that a generic proceeding be held for the IRP proceeding, and that you follow Act 62 as it's written, and to the extent that this commission believes that other things need to be addressed in connection with the IRP, that the appropriate and proper mechanism by which to do that is through subsection E, which allows this commission to promulgate rules and regulations in furtherance of that specific section of the code. That's all I have, Mr. Chairman. Thank you very much.
Thank you. Ms. Fox.
Thank you. I just have a few things for clarification. This oral argument involves 16 dockets, and Lockhart is involved in only 2 of those. So a lot of this just does not apply to Lockhart, but I wanted to make sure the commission understood that. but we are required to file an IRP. And Mr. Witt mentioned a letter that Ms. Doolin filed yesterday. Lockhart also signed on to that letter with respect to the IRP issue only. Lockhart, the reason that a lot of these dockets don't impact Lockhart is that Lockhart serves less than 100,000 customer accounts, and so Chapter 40 and Chapter 41 of Title 58 do not apply to Lockhart because of that. So all of the net metering, renewable energy resources requirements, and those kinds of things don't apply to Lockhart. They're a very small company. They purchase most of their power from Duke. What they do generate on their own is almost 100% renewable energy, hydro. So they're a little bit different from the other utilities, very small. But I would say that as far as the IRP issue, Lockhart is required, they last filed their IRP, their comprehensive IRP in 2017. So with the statutory requirement to file a comprehensive IRP every 3 years, they have to file in June, no later than June 16th of 2020. And so in addition to all of, we agree with the other utilities that a generic proceeding is not necessary because the statute is very detailed, and not only with respect to what is required to be in an IRP, but providing those processes for people to intervene and have input and, remedies for, they can propose alternatives, the commission can modify plans. All of that is new. So in addition to agreeing with the other utilities with respect to that, Lockhart actually has a timing issue. So if you have a generic proceeding that concludes in mid-2020 with utilities filing new IRPs in compliance with this new stuff by the end of 2020, we just can't do that because we're statutorily required to file our next IRP in June. I think that's all I had. I would like to also mention that we, on behalf of Lockhart, we're not waiving any right to object to interventions or anything like that. Don't have any plans or knowledge of that, but we want to reserve any rights that we have in that regard as well. Thank you.
Thank you. Okay, we'll go to response from the movements. Yes, sir, Mr. Nelson. Excuse me, hang on, Mr. Holman. Let's get Mr. Nelson.
I'm not quite sure where we fall into this, who we are here, but I would like to make some comments regarding what all the parties have said already.
We'll be happy to hear your comments.
Thank you. And you'll excuse me, but we seem to be covering a lot of topics today, so I might skip around a little bit here. But I want to address probably first the IRP issue. We don't object to the generic or the single docket that has been proposed by the various interveners, in this case, or the movements here. We don't know that, I don't know necessarily that a generic or a single docket is necessary because this commission already has outstanding orders and procedures in place to consider the IOUs. Filing dates have been established by prior commission orders. Order number 2012-97, 2012-215 sets filing dates. Lockhart Power additionally had filed with the commission a letter dated July 19th in which they pledged to file not later than June 16th of this year. So those are already established. And the sole reason there would seem to be for a single docket under the IRPs would be to set a consistent format for all of the utilities to follow. So while we're don't necessarily believe that single docket is necessary, we're not opposed to it if the commission believes that would establish a standard format for all of the utilities to use. I want to go back to one thing that Mr. Burgess just talked about, which was our generic comments that we started with. And ORS had requested that the commission require utilities to file an application before they file testimony. And I believe that this is consistent with South Carolina Code Annotated Regulations 103-823, which provides for the filing of an application in all cases in front of the commission. In this case, where we were dealing with these avoided cost dockets, the applications and testimonies were filed at the same time, and that gives all of the other interested parties very little time in which to attempt to conduct discovery and form their own opinions, especially in a lot of these cases where we're employing outside expert witnesses. And I want to go back to that point for a minute too, because there was a point made regarding the fourth point that Mr. Bateman made, which was ORS requesting the parties be able to use video conferencing. And I'm not sure if the commission's aware, but we employ E3 as our expert witness in these avoided cost dockets, and they are located in California. We ran into a situation with one of the last cases where we had used this company where by the time the hearing had been canceled due to inclement weather, we already had them on a plane headed here, and the costs were fairly high to fly somebody here from California to testify. So it would result in significant savings to us and then eventually the companies and eventually the ratepayers if we could use video conferencing to present those witnesses. One other thing is, and that's discussing the interconnection dockets. ORS would recommend that the Commission administratively close dockets 2019-194, 195, 196, and 197E, which correspond to the individual IOUs, and open a single generic docket sometime probably around mid-November to solicit procedural comments relating to interconnection procedures at that time. We believe that a single generic docket is preferable than individual dockets for IOUs due to administrative ease and judicial economy. From my understanding, it's in line with what other states, including North Carolina, have done, and it avoids the potential for confusion arising from the promulgation of interconnection standards that are unique to the various IOUs. One standard set makes sense, and therefore we believe that that could be handled in a single docket. I'm probably forgetting something, but I think that's all I have right now. Thank you.
Thank you. Mr. Holman.
I'll be brief, and I did want to also say thank you to Rebecca for getting that letter together and helping us narrow the issues, and for that reason, I'm glad we don't have 10 issues here today. We only have 1 or 2, but on this generic proceeding, the Commission has had generic proceedings in the past. The statute just passed this year allows for multiple generic proceedings. And there's nothing that stops this Commission from having other generic proceedings. And so I think there's a bigger, very interesting lurking legal issue perhaps about the Commission's authority in light of the Administrative Procedures Act that Duke has raised. I would submit to you that line of cases about rulemakings and binding norms is inapplicable. A lot of the concerns there are inapplicable where the parties are participating. The concern in those cases, those APA rulemaking cases, is that an agency like DHEC might haul off and just announce a new standard, and then everybody's got to comply with it throughout the state, and they don't have any notice, they don't have any ability to challenge it, they can't participate in it. That's what those cases are about. This Commission is much different than DHEC. You have much more authority to exercise your power, and you're operating in an adjudicatory way that DHEC is not, where the parties have the ability to participate and protect their rights. So a generic proceeding, I would submit to you, is to find that you can't do this because it would be a rulemaking would actually be a major rollback of your authority, not just in this particular docket and in this statute, but across the board, and should not be done lightly. There's a reason this Commission has done it in the past. There's a reason the General Assembly has given you the authority to keep on doing it, and that is because it makes sense. Where you've got cross-cutting big issues, let's knock them out so that we don't spend all of our time in the weeds on these various proceedings. Thank you.
Thank you.
Very briefly, I want to note for the record, the letter that you have from all the interested parties, we were omitted, and it wasn't on purpose. We worked together with Duke, and that was an error. So thank you for putting that together, Rebecca. We certainly concur in that, but just for the record, and I think counsel for Duke will acknowledge that we were left off. And so, yes, and inadvertently. So I don't want you to think that we're the fly in the buttermilk up here, okay? Anyways, again, Jamie Golden on behalf of JDA, we don't object to video conferencing for ORS. We think that makes very, very good sense. No objection there. The one thing I'd like to follow up on Mr. Hallman's comments, you folks, you seven do sit as quasi-judicial body, and from the review committee to the legislature, they've always treated you as such. Guidelines and rulemaking are part of what you do, and with participation from the parties, it's typically preferred rather than going through the promulgation of regulations, going through the committee process at the General Assembly. That's in line with exactly what it is that this agency does, sitting quasi-judicial as you do. And so I know from my experience and in my years, I think that's the preferred procedural route. Back to one thing that I briefly talked about, and I think there was no pushback on from anybody, it's just confirming that we're going to have an integration study. That language, if you look, is permissive, but it's permissive as to the commission, as to the ORS. I've heard nobody object to it. We don't object with Mr. Burgess or Ms. Smith's request. We think it's clear it has to be utility specific, so that's not in contention either. What I would ask, and I don't get to ask you the questions, but if there's a possibility that we could get that on the record, that the commission or the ORS intends to move forward with the study in Act 62 at a time certain, not a time certain, just in the future. That's essentially all I would ask this commission. I'm glad to answer any questions on that if necessary.
Thank you. Any other response, companies? Or any other, what, hang on one second, Mr. Witt.
Mr. Chairman, members of the commission, briefly again, we want to support the rebuttal from Attorney Hallman on a generic docket. We gave you an example where you've done it in the past, and certainly in my experience, there's been multiple generic dockets, and you have the authority to manage your dockets and to have a generic docket. So we think any argument to the contrary is just wrong, and we support the generic docket. Thank you.
Thank you.
Thank you, Mr. Chairman. Chad Burgess again for Dominion Energy, South Carolina. I stand corrected. There are two places in Act 62 where you are allowed to have a generic docket. And one is for the competitive procurement of energy with respect to creating programs, and that is specifically at 5841-20E2. So the General Assembly is clear. You can have a generic docket there. And also with respect to net energy metering, which is under section 5840-20, it says under C, no later than January 1, 2020, the commission shall open a generic docket. So there are two instances where generic docket is clear that you can do. Where I could not find generic docket was in the IRP section, because it doesn't exist. The commission, it is black letter law that you only have the authority to do things for which the General Assembly grants you authority to do. And if the General Assembly wanted you to establish a generic docket using those two code sections that I just previously cited, they would have included that in the IRP section. They did not. They included language with respect to promulgating regulations. Those are two different things, and we would continue to argue with you and recommend that you reject the position of the other parties that a generic docket be established for IRP. We think if there are items that you want to address in IRP, that is to be handled, and you're required to handle that under a rulemaking procedure, not under a generic docket. Lastly, with respect to transparency and of the like, the procedure for an IRP, and Mr. Holman's right, it's different than what it was previously. There is an opportunity for parties to file discovery after the utility submits its plan. There is an opportunity for other parties to submit their own plans if they desire to do so. And this commission is required to issue an order finding whether or not the utility was in compliance with the statute for their IRP. And if the utility is not in compliance, then the utility has 60 days within which to correct its filing, which then has to be reviewed by this commission again, as well as the Office of ORS, and they have to make a statement with respect to the IRP as a result of that corrective filing. So I certainly don't want this commission to leave here with the thought or impression that transparency is not afforded by following the statute as it's written today. It clearly is. And again, we would submit to you that, that the language in the statute on IRP is clear and generic proceedings are not permitted. It has to be done through a rulemaking procedure if that's what is desired to be done. Thank you, Mr. Chairman.
Thank you. Smith.
Thank you. Duke Energy Carolinas and Duke Energy Progress subscribes to the comments just made by Council for Dominion Energy. We believe the IRP statute says promulgate regulations and that the legislature intended that to be the process. But I won't reiterate any more than that, except that we agree with everything he said and regarding the promulgation of regulations, and that was stated by myself earlier in our July 5th filing. Two other points. The discussion of video conferencing, the parties, Duke Energy Carolinas and Progress wanted to get on the record. We have no immediate objection to video conferencing, but we also know that we haven't seen any testimony yet to know how video conferencing might impact our ability to cross-examine, et cetera, what the technical parameters of that are. So we just want to note for the record that while we have no immediate concern with that, that doesn't mean that we won't in the future. We have every intention to be cooperative in this regard, but I didn't want to walk away if we had a problem later without providing that caveat. Finally, there was a section, there was some statements about the case law that I mentioned. That case law is about the Administrative Procedures Act, and Mr. Holman was correct that a lot of that case law is about notice and participation. However, when you have parties taking the position that participation or even the docket itself is outside of the law in terms of, in this example, the IRP statute, that isn't the same thing. And so those cases are still applicable as cited in the company's July 5th filing, and whether or not something is a binding norm is determinative of what is a regulation or not, and there's processes for that under the Administrative Procedures Act, and again, we point back to the wording of the statute. Thank you.
Thank you. Ms. Fox.
I just wanted to just mention, with respect to ORS's recommendation that the 4 interconnection guidelines dockets that are specific to each investor-owned utility be closed and that a generic docket be initiated to address a standard set of guidelines for all utilities. That is something we hadn't thought through. I have not talked to my client about that. I do know that Lockhart is so different from the other companies that I don't know that a single set of guidelines generally applicable would not need to be tailored for a smaller utility. So I just wanted to reserve the right to comment on that procedural issue later. Thank you.
Thank you. Commissioners, any questions?
Mr. Chairman.
Commissioner Whitfield.
Thank you, Mr. Chairman. I'd just like to say thanks to all the parties. This is maybe what the General Assembly did envision. I've heard some good arguments on both sides. I've seen some great legal work. But I want to press, and I'm going to give each of you an opportunity to respond just a little further. And you all have made some great points. But back to and Mr. Holman, you started out talking about it is a new day with IRPs. It really is a new day. We have not had that authority as other states have had in the past. And back to you, Ms. Smith, the Administrative Procedures Act, how you cited all that, and that's now been discussed. I guess I want to ask you, Ms. Smith, and maybe Mr. Burgess, Ms. Fox, the attorneys over here, when you talk about a generic docket, and we have had them in the past here, and I'm going to press you just a little further, Ms. Smith. You stopped just a tad shy, maybe you too, Mr. Burgess, but in your in your opinion, does a generic docket fly against the Administrative Procedures Act? In other words, we got some saying that we can manage that docket, and we do have the authority to manage that docket. And then, if I'm understanding you right, I think you stopped just shy of it, Ms. Smith, but are you and Mr. Burgess and others at your table, are you saying that a generic docket would be impermissible just because it doesn't mention it in the IRP section, as Mr. Burgess said? Are you saying that the way you read the Administrative Procedures Act, that it would be contrary to that?
Commissioner Whitfield, our focus for this particular proceeding has been on the IRP statute itself. And as I stated earlier, I haven't been able to find any authority other than the two instances in which I just mentioned a second ago that give the commission the right to do that. I also haven't studied the Administrative Procedures Act from the broad perspective about whether or not the commission has the overall authority to enact a general proceeding. I'm certainly aware that this commission has had general proceedings in the past, and I'm also aware that no one has objected to them. So in my experience, until someone raises their hand and makes a legal argument against something, we kind of march down that path. I'm not certainly prepared to stand here today and tell you without a shadow of a doubt that you don't have the authority to do that under the APA. I'm telling you, I don't know. I'd have to go look at that a little more closely. But what I am telling you with respect to the issue that we were called here today to talk about, which was the IRP docket, I do not believe this commission has the authority to do a generic docket under the language of that statute.
Thank you, Mr. Burgess. Before I go to the other table, Ms. Smith, if anybody else from your table wants to comment, and then we'll go to the movements.
One other thing I wanted to note about generic dockets. In general, the commission has had generic dockets, may have some more. I think there are a couple on the commission's radar coming up in the next few weeks. And the effect of the generic docket is what's important in the ABA, under the APA. If a generic docket fosters discussion or has the commission giving, guidelines, et cetera, that's one thing. But where a generic docket binds the parties, thou shalt file this, the word reasonable means that, this study includes X, Y, Z. Those are the types of things that we believe are binding norms, and if something is a binding norm, it should be promulgated as a regulation under the APA versus being determined in a generic docket. If every party agreed that this is that there is a certain path forward and all parties proceed in that way, Mr. Burgess is right, then that's the way it would go. But this is a little bit different where the company believes the legislature intended if the commission was going to fill in gaps, it would do so via promulgation of regulations. That is separate and apart from the commission's general ability to have a generic docket. And again, it's the effect of the docket that triggers the APA.
I'm hearing you right, and I think you said this the first time you were up. It's basically, in your mind, guidelines versus regulations.
Yes, sir. We don't believe the commission can issue regulations via a generic docket or via guidelines.
Yes, ma'am. Thank you. Nobody else, Ms. Doolin or Ms. Fox? Yes, sir.
I'll confess this is an interesting area of administrative law. Where I come to it from is, what is your authority in a proceeding? You have the authority to determine the rights of the parties. And if you can do that in a docket, I think just like you can consolidate dockets, I think you can have a generic docket that is cross-cutting across parties. And so if in any one of these IRP proceedings, you might say, here's the definition of reasonable we're going to use, and what you've done, Dominion, is reasonable or isn't. Okay, does that violate rulemaking? Because what I'm hearing is, if you ever make a determination in any of these proceedings, generic or not, that is applicable across the state, you got to go through rulemaking. And I don't think that General Assembly had that in mind at all. This statute expressly endorses generic rulemaking. Mr. Burgess said he didn't know any legal authority, but then he found it in Act 62 and has read it to say that only in those proceedings can you have generic dockets. That's not what it says. It's not what the Act says. The Act says you are authorized to do it in net metering and the competitive renewables. It does not say you can't do it anywhere else. So I think that your past practice that the General Assembly has been aware of for decades, they could have said no more generic dockets except here. They didn't do that. They understand what you're doing, and they want you to run this in the efficient way that you think is you have authority on. And Commissioner Wishfield, I think that this reading, that if you're ever making a ruling in a proceeding that affects, that elucidates the meaning of a statute, that has to go through rulemaking, cannot be the law.
Mr.
Commissioner
Holman,
Whitfield, if we can hang on for a second, you hold that thought. We're gonna take a short 5-minute break and then we'll come back.
thank you.
Okay, we're going to go back to Commissioner Whitfield.
Yes, sir. I think the chairman's going to stand for a minute.
Okay.
Yes, sir, Mr. Hallman. I don't know if you were finished or not, but go ahead.
I think your question was whether or not, about the APA and whether or not, I guess how it intersects with the rulemaking provisions. I guess our just basic view is you have the authority to resolve proceedings, to create and conduct proceedings that can have effect on multiple parties, as long as everybody gets notice. I think the statute, the IRP provision itself says a proceeding. So actually the statute talks about a singular proceeding. We've not asked to consolidate yet, but we might. But I think the General Assembly clearly was thinking in terms of it's a new day. They gave you the authority to promulgate regulations if you think that's necessary. But I also get the sense the General Assembly wants to get some stuff done and get this thing rolling. So we think you can do it through a generic proceeding.
Well, I certainly appreciate your answer. And I do have one follow-up with you, and it's kind of down a different path. I know this has been, we've been right on the edge here with this APA versus generic docket thing, but I want to ask you your opinion or thoughts about the utilities assertion about these utility-specific studies and the need they express for the balancing of each utility. You've heard Ms. Fox say that certain chapters don't even apply to Lockhart because of their size. And, of course, we have different electric IOU territories and different customers, different makeups, different. Just wanted to hear your opinion about the comments they keep making about utility-specific balancing for each utility for that study.
I think we agree that there should be utility-specific. Are you talking about interconnection?
Yes.
That there should be some degree of, there's going to be specificity as to the utility, but where there are, excuse me, I'm sorry, there's a lot of feedback here. Where there are cross-cutting issues, that the commission should take the opportunity to resolve those, be it in a generic proceeding or through consolidation. That's kind of our general approach on all this. We think an IRP is particularly important.
Thank you, Mr. Hallman. Anybody else from? That's all I had, Mr. Chairman.
I'm sorry, can I just respond to your question, Commissioner Whitfield? Just thinking about it during the break, I just wanted to clarify that it is not Lockhart's position that the Commission does not have authority to conduct a generic proceeding. We just simply think that it's not necessary with respect to the IRPs, nor is a rulemaking. The statute is very clear. Thank you.
I noticed you said that appeared to be differing a little from the other folks at your table, so I did hear that.
Right. Thank you.
Commissioner Urban.
Thank you, Mr. Chairman. Let's take the easiest one first, and I think could all agree that it would save the ratepayers and the parties money if we didn't have to fly out of state experts to come and sit around and wait for their turn to testify. So just so we can have some general agreement, does anybody object to using the video testimony under oath for out-of-state experts? I think that's just common sense. Anybody want to speak to that? Object to it?
Not object, but I want to clarify, is that for all witnesses or just for the ORS at this point?
I would think it should apply to all witnesses. Okay. That would be my thought. You have full right of cross-examination.
JDA does not object.
You could, we'll certainly instruct the witness if we take a break not to discuss their testimony with anyone, those type, things, of course, but,
I guess we were thinking about it in terms of ORS. I don't think we would have an objection, but I haven't checked with my clients. And
Sure.
It makes me a little uneasy to think about all of our witnesses being video.
I understand. Well, why don't you talk about it with your clients? My thought is that, talk with your clients and see if they can agree. It would save a lot of money and time and for everyone involved. And that ultimately gets passed on to the ratepayers, unfortunately. And I understand Duke's position. You said earlier that there are no immediate objections, but you want to reserve your rights. Is that right, Ms. Smith?
Yes, sir, and that was limited to the Office of Regulatory Staff. We're
Right.
happy to work with parties for an efficient hearing, but technology is a sticky thing, and we believe we need to see testimony before we fully
Right.
agree to anything along those lines.
All right. But you would have no objection to ORS using their California expert by video?
I know of no objection right now, sir, but when I see their testimony and we determine the extent of cross-examination, we may change that position.
Understood. Well, to the extent that parties can work on that, I think it would be helpful for all concerned. And so I would encourage you to continue to talk and see if we can reach a general agreement about that. I wonder if I heard, correct me if I'm wrong, but I thought that, Mr. Burgess, you said Dominion had no problem with filing an application with your integrated resources plan that disclosed any rate increase impact. Is that true?
I don't think I said it that way.
Okay.
I think what I said was that request that ORS was making was the first time.
First time
I'd
you'd heard it.
about that, and before I can commit
Sure.
the company to do or not do something, I need to have time to consult.
Fair enough. So I guess the next point is, I would ask all parties to consult with your clients in hopes that we can reach an agreement. But again, in the interest of transparency, I think it would serve us well to have that application filed with your IRP, disclosing any rate impacts. Just a matter of fairness, it puts all parties on notice of what's coming, and they can, you see where I'm going with that?
Yes, sir, I absolutely understand. I will say this, I'm not aware of an IRP ever having a rate impact. And I think the rate impact was a little bit different than the application itself. I think that was where they thought ORS's position was, and I don't want to misstate it, so if I do, correct me. But I think their indication was if there is a rate impact, then the utility should accompany a notice with that.
Correct. That's right. And is that correct, ORS?
Yes, sir, that is correct. And if I could make one other point, when we were talking about the video conferencing, we're not talking just about the IRP process. We're talking about all of the dockets that are set up here because really, I don't know if we're going to have witnesses in the IRP, but I know we already are working with experts in some of the other cases.
Right. So please continue to talk with your clients, and just so that we don't wait to the last minute, I would encourage the parties to get a written stipulation that you can file with the docket from opposing counsel that will provide for a video testimony at any of our hearings, just to reduce cost. Is it my understanding that all parties agree that the integration studies need to be utility specific?
Jamie Golden, JDA. I believe that's in the statute that it is.
I thought so. I thought it was. It makes sense that it should be.
So I think that's part of the reason we're all in agreement. That
Yeah. You agree, Mr. Burgess?
Yes, sir. We
All right.
absolutely agree.
Very good. Do you all also agree that we don't need to make a decision today or next week or next month about whether or not we're going to have a generic docket, that decision could be made later? Or are you asking for immediate just ruling on that?
As to the IRP process?
Yes, sir.
The interconnection.
The
I'll let,
IRP process. I'm just
Okay.
curious. And we've talked a lot about it, but the timing, since we don't have any IRPs being filed this year, we've got a lot on our plate already. I'm just wondering, maybe we could get through these next round of hearings
The only time-sensitive thing that I see is just getting on paper that y'all are going to commission a study for each utility on interconnection. As to IRP, generic or not, interconnection, I think that was y'all's request, that that be a generic proceeding. I would, that one might be a little bit more, but I don't think it's anything that has to be decided this calendar year. There's nothing in the statute, to my knowledge, that puts a limitation on that. But I do think as to the study for integration, all of the rest, these integration charges that will be coming up, that all, has a part of just confirming that we will be looking at that.
Could you all consider entering into a consent order, setting out the integration studies, the timeline, that type thing? Could you help us with that?
Would be glad to. I think it takes the commission or ORS to confirm that they will go forward with it, and then we would get dates. Is that something y'all are open to?
Any objection to that?
We would have no problem working with the other parties on some type of proposed consent order to submit to the commission with respect to integration.
Because you know what your needs are better than we do in the sense of what kind of time frame you need it.
I absolutely agree. We certainly know what our needs are.
Right.
I think we've heard a lot from other parties as to what they think our needs are too. So yeah, we can work with that.
So I think that if we could just have a consent order, that would be the best way to resolve it. And yes, sir.
Make sure that mic's on or you're right in front of it so they can
Party's
pick you up.
position on the timing of if there were a generic IRP proceeding, what the timing on that would be. To the extent Dominion takes the position that it needs to file in February, and I'm not sure that is their position. I think they've said they plan to file in February. But to the extent they say they need to and they have to legally do that, then I would think a generic proceeding would need to take place before that. Would be helpful for it to take place before that to give some guidance for them as they move towards their filing.
So I just want to be clear. I thought we were talking about the integration studies with respect to the consent order.
That's what we were talking about, integration studies.
All right,
only,
I'm sorry.
only at this point, yeah.
Okay, very good, sorry.
Well, I want to thank all the attorneys involved. You've really helped us kind of understand better what everyone's role and responsibility is going to be, and you were able to resolve a lot of things prior to coming here today, and so I commend you on your cooperation and spirit of working together and trying. We're going to encourage more of that because we are dealing with a new act. We are learning as we go, and to the extent that we can all agree on a process and procedure and a schedule, that makes it easier for everyone. And we'd rather empower you to make those decisions than just order, do this, do that. It gives you more flexibility, and you can work out your differences, and you don't have to be involved with that. So I encourage you to do that. And that goes for, the IRP process as well. There are no appeals when there's a consent agreement, and all parties are in agreement with how to proceed. So again, in the interest of time and reduction of cost and delays, we would love to have an agreement, a universal agreement on how to proceed, and I think that would be very helpful. Didn't mean to cut you off.
No, sir.
Go ahead, Mr. Nelson.
I didn't want to cut you off, sir. I just wanted to mention on the integration study, there's been some discussion of that, and I hadn't addressed that. And under Section 58-37-60 now, it requires this integration study. It says the Commission and ORS are authorized to conduct this. There's no timeline specifically set regarding this integration study, and I think we have our plates pretty full right now with what we're dealing with interconnection and IRPs. So ORS's recommendation would be to push this integration study out for some time. We also think it would be expensive. It's going to cost some expense for the Commission and or ORS to conduct this study. And again, with what we're incurring currently, we would ask that this be pushed out to sometime next year.
Commissioners. Commissioner Howard.
Mr. Nelson, couldn't it be that an integration study would be an important integral to an IRP?
I think those are not interdependent. I think those both could be considered separately. The IRP for each individual utility is going to be based on that specific utility, whereas an integration study is more based on emerging technologies and things that are not quite so clear, that therefore probably may not be set in stone to be included in the company's.
That's why I asked the question, because an IRP, of my understanding, goes out for like 10 years. It's not just like an annual thing, it's like a look into the future type thing, which would, in my opinion, could come into play in IRP in later years down the line. That's why I asked the question.
And I'll admit, Commissioner, that's true. I mean, if we were talking 20, 30 years ago, developments in energy weren't very much, and you could project out for 10 years. I think things, obviously, there are a lot of emerging technologies now, but again, I don't know that those are interdependent. I believe that one could be conducted without the other. I think we proceed with the 2020 IRPs by the 4 utilities, and then at some point we start dealing with this integration study.
Thank you. Commissioners, any other questions? Okay. If not, we thank everybody for your participation in these oral arguments, and we are adjourned.